The Constitution begins with "we, the people." But for centuries, people didn't include women as equals. Even today, women's rights in America rest on a patchwork of laws and court decisions that can be reversed at any time, as we saw with the Dobbs decision in 2022. Despite meeting the constitutional requirements for ratification, the Equal Rights Amendment remains in limbo. Why? The answer reveals who truly controls our democratic systems and what's at stake for everyone, regardless of gender, if explicit protection against sex discrimination continues to be denied. Hello, friends. Think about this. When President Biden recognized the ERA as the 28th Amendment in January 2025, it should have been a historic moment. America finally joining 85% of countries worldwide with constitutional gender equality. Yet even with 78% of Americans supporting it, powerful forces keep blocking its path. The gender pay gap persists. Women ages 25 to 34 still earn just 95 cents for every man's dollar. But this isn't just about numbers on a paycheck. This is about fundamental protections that can disappear overnight, leaving millions vulnerable. Let's understand what's really happening here. Would you believe that the document that founded America doesn't actually guarantee equal rights for women? It sounds almost unbelievable in 2025, but it's absolutely true. The U.S. Constitution, the supreme law of the land, contains not a single word explicitly protecting half the population from discrimination based on sex. This isn't just a technical oversight. When the Constitution was drafted in 1787, women were deliberately excluded from its protections. They couldn't vote, own property independently, or even testify in court in many cases. It took 133 years after the nation's founding before women finally secured the right to vote through the 19th Amendment in 1920. But while that was a monumental victory, it addressed only one aspect of equality. So what about the 14th Amendment? Doesn't it guarantee equal protection of the laws to all Americans? In theory, yes. But in practice, the application of this amendment to sex discrimination has been inconsistent at best and completely inadequate at worst. Let me walk you through why this matters. Unlike clear prohibitions against racial discrimination, sex discrimination cases have been treated differently by the courts. The Supreme Court didn't even acknowledge sex discrimination under the 14th Amendment until 1971 in Reed v. Reed, and even then, the court established what's called intermediate scrutiny for sex-based classifications, a lower standard than the strict scrutiny applied to race, religion, and national origin. This difference isn't just legal jargon. It literally means that discrimination based on sex is easier to justify under our Constitution than other forms of discrimination. When courts apply intermediate scrutiny, government policies that discriminate based on sex only need to substantially advance an important governmental objective, a significantly lower bar than proving a compelling state interest required for racial discrimination cases. Perhaps most shocking was Justice Antonin Scalia's blunt assessment in 2011 when he stated, "The Constitution does not prohibit sex discrimination. It prohibits race discrimination. It prohibits discrimination on the basis of religion, but it doesn't prohibit discrimination on the basis of sex." Coming from a Supreme Court justice, this statement laid bare the constitutional vulnerability women face. This gap becomes even more glaring when you realize that approximately 85% of countries worldwide have explicit gender equality provisions in their constitutions. The United States, which prides itself on being a global leader in democracy and human rights, remains a stubborn outlier. The consequences of this constitutional gap extend far beyond symbolic significance. Without explicit constitutional protection, women's rights in America rest on a foundation of statutes and court decisions that can be modified, reinterpreted, or even revoked as political winds shift. Think about that for a moment. Fundamental rights that depend on which judges sit on the bench or which party controls Congress. Let me give you a concrete example of what this means. Under the current interpretation of the Constitution, a law that discriminates based on sex can be justified more easily than one that discriminates based on race. The lower intermediate scrutiny standard creates a situation where sex-based discrimination simply faces fewer constitutional hurdles. What happens when rights aren't constitutionally protected? They become vulnerable to erosion or elimination through simple legislative action or judicial reinterpretation. We've already witnessed how rights once thought settled can suddenly become precarious when they lack explicit constitutional grounding. This is precisely where the Equal Rights Amendment comes in. The ERA's straightforward language, "Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex," would elevate sex to a suspect classification deserving the highest level of judicial protection. This would fundamentally transform how sex discrimination cases are evaluated, requiring the same strict scrutiny standard applied to race. With the ERA, any law or government action that discriminates based on sex would face the highest constitutional hurdle. It would need to serve a compelling governmental interest. But here's the twist in this constitutional saga. The Equal Rights Amendment was first proposed in 1923, just 3 years after women gained the right to vote. Think about that for a moment. The same amendment we're discussing today has been struggling for recognition for 100 years, surviving decades of fierce opposition that reveals America's deep ambivalence about true gender equality. Alice Paul, a suffragist who had fought for the 19th Amendment, didn't rest after women won voting rights. She drafted the original ERA with a straightforward message: "Men and women shall have equal rights throughout the United States and every place subject to its jurisdiction." The wording evolved slightly in 1943 to what we know today. "Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex." Just 24 words that should have been uncontroversial, yet their journey exposes the fault lines in American politics. For nearly 5 decades, the ERA faced continuous roadblocks in Congress. Representatives and senators introduced it year after year, only to watch it stall in committee or face defeat on the floor. The persistence finally paid off when Congress passed the ERA on March 22, 1972, attaching a 7-year deadline for state ratification. Initially, momentum seemed unstoppable. Within just 1 year, 30 states had enthusiastically ratified the amendment. The remaining 8 states needed for the 3/4 requirement seemed all but guaranteed. But then something unexpected happened. A conservative backlash organized around a charismatic leader named Phyllis Schlafly. Schlafly formed the Stop ERA movement, where STOP stood for Stop Taking Our Privileges, presenting a fascinating framing of women's traditional roles not as restrictions but as protections to be preserved. She argued that the ERA would force women into military combat and eliminate their right to be financially supported by their husbands. ERA will impose on mothers the equal 50% financial obligation for the financial support of their infant and minor children, she warned audiences across America. These arguments played directly into fears about changing gender roles during a time when American society was already experiencing significant cultural shifts. Traditional values provided certainty in uncertain times, and Schlafly's campaign masterfully positioned the ERA as a threat to social stability rather than a guarantee of basic rights. The strategy worked. The amendment's progress slowed dramatically, and by the original 1979 deadline, only 35 states had ratified, 3 short of the required 38. Congress granted a 3-year extension, but no additional states joined before the new 1982 deadline expired. The ERA appeared dead, a relic of a failed movement. What's even more fascinating is that 5 states, Idaho, Kentucky, Nebraska, Tennessee, and South Dakota, attempted to rescind their earlier ratifications before the deadline. This unprecedented move created a legal puzzle. Does the Constitution allow states to take back their yes votes? Article 5, which outlines the amendment process, says nothing about rescissions, suggesting that once a state ratifies, that decision may be final. Then, after decades of dormancy, something remarkable happened. In 2017, Nevada suddenly ratified the ERA, followed by Illinois in 2018. When Virginia became the 38th state to ratify in January 2020, supporters celebrated what appeared to be the final step in the amendment's journey. Technically, the ERA had reached the 3/4 threshold required by the Constitution. But procedural questions complicated what should have been a straightforward certification. Does the expired deadline invalidate the recent ratifications? Are the attempted rescissions legally binding? The American Bar Association doesn't think so. They've passed a resolution affirming that the ERA has met all constitutional requirements for ratification under Article 5. Yet the amendment remains in limbo, neither fully recognized nor definitively rejected. The Constitution's amendment process never anticipated a scenario where an amendment would reach the required number of states decades after its proposed deadline. This constitutional limbo might seem like a technical legal debate until you realize what's actually at stake. When the Supreme Court overturned Roe v. Wade in 2022, it revealed a troubling truth. Rights not explicitly protected in our Constitution can vanish with a simple shift in judicial philosophy. The Dobbs decision didn't just end federal abortion protections, it demonstrated the fragility of any right that depends on court interpretations rather than clear constitutional text. Think about what this means in practice. Judicial decisions, however powerful they may be, are vulnerable to being overturned when new justices with different legal philosophies join the court. And Justice Clarence Thomas made this vulnerability crystal clear in his concurring opinion. He didn't stop at abortion rights. He explicitly suggested the court should reconsider other precedents protecting contraception access and same-sex marriage. These rights, also built on interpretations of constitutional privacy and due process, could be the next dominoes to fall. But here's where things get interesting and hopeful. In states with their own equal rights amendments, we're already seeing how explicit constitutional protections make a difference. Take Pennsylvania, for example. Their state Supreme Court ruled in Allegheny Reproductive Health versus Pennsylvania Department of Health Services that the state's ban on Medicaid coverage for abortion constituted sex discrimination under Pennsylvania's ERA. Similar protections have emerged in Connecticut and New Mexico, concrete examples of what a federal ERA could accomplish nationwide. The impact of constitutional equality extends far beyond reproductive rights. Let's talk about your wallet. Women today still earn just 85 cents for every dollar men make, with this gap narrowing at a glacial pace over decades. You might think, don't we already have laws against pay discrimination? We do, but these laws can be weakened or strengthened with each new administration, creating a constant back and forth that prevents real progress. Workplace discrimination persists despite existing protections. Women face hiring biases that prevent them from getting jobs in the first place and encounter significant barriers when seeking promotions. A substantial number of U.S. adults report that women are treated differently by employers, contributing to that stubborn wage gap that refuses to close. The ERA would fundamentally change this dynamic by providing a constitutional foundation for equal pay laws. Rather than leaving these protections vulnerable to political whims, the amendment would elevate sex to a suspect classification. This means any law or policy that discriminates based on sex would face the highest level of judicial scrutiny. The same standard applied to discrimination based on race, religion, or national origin. Constitutional equality would also strengthen protections for LGBTQ+ Americans. Courts have increasingly recognized that discrimination based on sexual orientation or gender identity is a form of sex discrimination. In Bostock v. Clayton County, the Supreme Court established that Title VII of the Civil Rights Act protects employees from being fired for being gay or transgender. But again, this protection rests on judicial interpretation rather than explicit constitutional text. The current legal landscape for anti-discrimination protections is a patchwork quilt with holes that vary from state to state and administration to administration. Some laws offer strong protections in certain contexts, but leave gaps in others. The ERA would create a consistent, nationwide standard for evaluating all forms of sex discrimination. No more wondering whether moving to a different state might cost you your rights. This constitutional foundation would also make it harder for discriminatory practices to hide behind tradition or custom. Currently, some policies with discriminatory effects can survive legal challenges by meeting only the intermediate scrutiny standard. Under the ERA, these policies would face much tougher scrutiny, and many would likely be struck down. The benefits are clear: stronger protection for reproductive rights, more effective enforcement of equal pay laws, and enhanced safeguards for LGBTQ+ Americans. The ERA would transform American rights by placing equality on solid constitutional ground rather than the shifting sands of judicial interpretation. Placing equality on solid constitutional ground sounds straightforward, until you follow the money and power. While nearly 9 in 10 Americans want the ERA certified as our 28th Amendment, a small but influential coalition has managed to keep it suspended in legal purgatory for over 50 years. Their success exposes the remarkable gap between public opinion and political reality. The numbers are staggering. A June 2022 poll by Data for Progress revealed that 85% of Americans support the Equal Rights Amendment, including 93% of Democrats and 79% of Republicans. Even more recently, in December 2024, 61% of voters supported President Biden publishing the ERA as the 28th Amendment. This overwhelming cross-partisan support begs an obvious question. In a democracy, how can something with such broad public backing remain unimplemented? The answer lies in the deliberate political and legal obstacles erected to block constitutional change. In January 2020, the Trump administration's Department of Justice issued a memo claiming the ERA was no longer valid because its ratification deadline had expired. This wasn't merely a legal opinion, it was a political barricade. When the Biden administration took office, their DOJ called this interpretation inaccurate, yet still stopped short of ordering the ERA's certification, revealing how institutional inertia works across party lines. Let's look at the technical arguments against certification. The first centers on Congress's power to set and enforce deadlines for constitutional amendments. While the 27th Amendment took 203 years to ratify without facing deadline issues, ERA opponents insist this one particular deadline is suddenly sacrosanct. The second argument involves 5 states, Idaho, Kentucky, Nebraska, South Dakota, and Tennessee, that attempted to rescind their ratifications. However, historical precedent suggests these rescissions hold no legal weight, as no state has ever been permitted to withdraw its approval of a constitutional amendment once ratified. These legal maneuvers hide a deeper political transformation. The ERA wasn't always a partisan lightning rod. In fact, the Republican Party was the first major party to endorse it back in 1940, showing how dramatically political alignments have shifted over time. Today, opposition to the ERA comes primarily from conservative legal organizations concerned it might strengthen abortion rights following the Dobbs decision and expand protections for LGBTQ+ Americans, revealing how the amendment has become entangled in today's culture wars. The courts have become another battlefield in this constitutional struggle. In the Virginia v. Ferriero case, the Attorneys General of Virginia, Illinois, and Nevada argued that the Archivist of the United States had a ministerial duty to certify the ERA after the 38th state ratified it. But the lawsuit was dismissed due to lack of standing, a procedural roadblock preventing the courts from even addressing the substantive questions. Meanwhile, efforts in Congress to remove the ratification deadline through Senate Joint Resolution 6 have faced significant political hurdles, including Senate filibusters that prevent even majority-supported measures from advancing. Looking at these barriers together reveals something important about power in America. Constitutional amendments aren't just legal text. They represent fundamental shifts in who holds rights and protections. The resistance to the ERA isn't simply about legal technicalities. It's about maintaining existing power structures that benefit from keeping equality as a negotiable political issue rather than a constitutional guarantee. This brings us to President Biden's remarkable January 17, 2025 announcement that he believes the ERA has cleared all necessary hurdles to be formally added to the Constitution as the 28th Amendment. While he stopped short of ordering the archivist to certify it, demonstrating the institutional caution that pervades this issue, his declaration provides a new foundation for future court cases. Even without formal certification, Biden's recognition means judges can now consider ERA-based arguments in discrimination cases, potentially reshaping legal interpretations even as the certification battle continues. So here we are, friends. After a century-long struggle, the Equal Rights Amendment stands at a constitutional crossroads. The remarkable truth is that despite having achieved ratification by the required 38 states, the ERA remains in political and legal limbo. Leading constitutional scholars like Lawrence Tribe and Erwin Chemerinsky firmly believe the ERA has met all necessary requirements and should already be recognized as our 28th Amendment. But as the 19th Amendment taught us, the path to constitutional change is rarely straightforward. Women fought for over 70 years to secure voting rights. This isn't just a legal technicality, It's about whether our foundational document will explicitly protect half our population. The question becomes, what can we do? We can advocate for the National Archivist to publish the amendment, contact our representatives, and join grassroots movements led by organizations like the